There is a particular kind of person who believes that consequences are for other people, not through any explicit philosophy, not through some articulated belief system that they've thought through and could defend. It's more instinctive than that, more reflexive. It's the product of a life in which the normal mechanisms of accountability, correction, reprimand, consequence, have consistently failed to reach them. A life in which enough money, enough lawyers, and enough time have always been sufficient to make problems disappear before they became permanent. These people exist at every level of society, but they are most dangerous and most visible when they reach positions of real institutional power. When they sit at the top of something large and profitable and surrounded by people whose job it is to agree with them. Marcus Ellroy had been that kind of person for a very long time. By the time he walked into a courtroom on a Wednesday morning in the spring of what would turn out to be the most consequential year of his professional life, he had spent 2 decades being told in 100 different ways that he was exceptional, that the rules that governed ordinary professional conduct were, for him, more like suggestions, that the legal system, in particular, was a mechanism to be managed, with the right firm, the right billing rate, the right strategy, rather than something he was genuinely subject to. He was about to learn otherwise. The learning would take approximately 60 seconds. Marcus Ellroy was the founder and chief executive of a technology and data services company called Vantage Parallel. The company had been founded 18 years earlier, had gone through 2 rounds of acquisition, and now operated primarily in the business intelligence and analytics space, with contracts across several industries, including healthcare, retail, and local government. It was profitable. It was well regarded in its sector. It had received industry awards and had been featured in regional business publications as a model of entrepreneurial success. Marcus himself had given keynote addresses, served on advisory boards, appeared on podcasts. He was the kind of figure who was described in his own company's press releases as visionary. He was also, according to the lawsuit that had been filed against him 18 months before the courtroom scene that would define his public legacy, a man who had systematically stolen from his employees. This is not a casual accusation, and it requires context. Vantage Parallel had, for a period of approximately 4 years, operated a deferred compensation program for senior employees. The program was straightforward in concept. Eligible employees contributed a portion of their salary, typically between 8 and 15%, into a company-managed fund that would be paid out at specific intervals or upon departure. The contributions were real money, withheld from paychecks. The fund was real. The agreements were signed. What the employees had not known was that Marcus had, over the course of 3 years, authorized the redirection of those funds to cover operating shortfalls in other parts of the business. Not borrowed, not tracked, redirected, without notice, without consent, without any documentation that the employees had agreed to assume risk with their own withheld compensation. When the program was quietly discontinued, announced in a 2-paragraph internal memo that cited changing strategic priorities, the employees affected were told that their contributions would be returned according to a repayment schedule that Vantage Parallel would communicate shortly. No schedule was ever communicated. 12 employees filed a joint civil claim. The combined amount of their withheld and redirected deferred compensation came to just under $900,000. Marcus's legal team had spent 17 months finding ways to delay, complicate, and obscure the proceedings. They had filed motions that went nowhere and then refiled variations of the same motions. They had requested extensions, missed deadlines, and challenged the scope of discovery in ways that served no purpose other than to extend the timeline and exhaust the resources of the plaintiffs, most of whom had taken out personal loans or depleted savings accounts, to fund the litigation, while the money that was rightfully theirs sat inaccessible. The judge overseeing the case had, by the time of the hearing in question, issued 3 formal admonishments regarding compliance with court orders and discovery obligations. She had extended deadlines she had not been required to extend. She had given the defense every reasonable accommodation. She was not inclined to give another one. Her name was Judge Sandra Morrow, 31 years on the civil bench. A reputation for patience that was real and well documented, and a reputation for the absence of patience, once that patience was exhausted, that was equally well documented and considerably more dramatic. The hearing that morning had been scheduled to address a discovery compliance order that Marcus's legal team had failed to satisfy for the second time. The order was specific. The company's financial records for a 36-month period were to be produced, unredacted, by a date that had now passed. This was not a complex requirement. It was the kind of documentation that a company of Vantage Parallel's size maintains as a matter of ordinary operation. The failure to produce it was not a logistical challenge. It was a choice. Judge Morrow knew it was a choice. Marcus arrived with his lead attorney, a man named Philip Carver, and 2 junior associates. He was dressed in the manner of a man who considers his appearance a form of argument. Charcoal suit, open collar, expensive watch visible at the cuff. He had the posture of someone arriving at a meeting he expected to run. The 12 plaintiffs were already seated on the other side of the room. They were not a monolith. They ranged in age from 31 to 58. Some had worked at Vantage Parallel for less than 3 years. One had been there for 14. They were dressed ordinarily, the clothes of people who had come to a courthouse on a workday because they had no choice. They were quiet. They had been through enough of these hearings to know that expecting anything particular was not wise. One of them, a woman named Grace Teller, who was 46 and had been the company's director of data architecture for 9 years before resigning, sat with a legal pad and a pen and made notes throughout every proceeding in a habit she had developed because it made her feel less helpless. $92,000 of her money was in that fund. She had contributed it over 7 years. It had been taken from her paycheck every 2 weeks and placed somewhere she could not access, and had since disappeared into the operational expenses of a company that still existed and still paid its executive team. She watched Marcus Ellroy settle into his chair across the room and open his phone without looking at anyone. Judge Morrow entered at precisely 9 o'clock. She was a trim woman in her early 60s, gray-haired, with reading glasses that she wore on a chain around her neck and a manner that conveyed, without effort or performance, that she was the most important person in any room she occupied. Not through intimidation, through the specific gravity that comes from knowing exactly who you are and having no need to demonstrate it. She sat. She opened the file. She did not look up immediately. When she did, she addressed Philip Carver directly. The financial records ordered on March 4th. Where are they? Carver said that the company had encountered technical complications in the extraction of the requested data from archived systems, and that his team was working diligently to... The records were ordered 6 weeks ago, Judge Morrow said. The original deadline was extended once, by 15 days, at your request. The extended deadline passed 11 days ago. You are now asking me to understand that the records are still not available due to technical complications. Your Honor, the scope of the request as originally... The scope has not changed, she said. The order has not changed. Has anything changed other than the date? Carver began a more detailed explanation of the technical architecture of Vantage Parallel's data storage infrastructure. Judge Morrow removed her reading glasses and set them on the desk in front of her. Mr. Carver, she said, I have been patient with this case to a degree that I will not defend as entirely consistent with my usual standards. I have granted accommodations that the record reflects were granted in good faith and not reciprocated in kind. I am not going to grant another extension. What I am going to do is give you and your client a clear choice. She put her glasses back on. Either the records are produced within 72 hours, or I will hold your client in contempt of court. That contempt finding will include sanctions commensurate with the 18-month pattern of non-compliance I have documented in this file. Do you understand? Carver said he understood and would convey the urgency to his client. Your client is sitting 6 feet to your left, Judge Morrow said. I assume he can hear me. Marcus had been listening. His expression throughout the exchange had been one that those present in the courtroom described in similar ways: controlled amusement, the faint suggestion of a smile that never quite formed, the quality of attention of a person who is watching a performance they find mildly entertaining rather than a judicial process that directly concerned their freedom. It was this expression that Judge Morrow had noticed. She looked at him directly. Mr. Ellroy, do you have any questions about the order I've just described? Marcus looked at his attorney, then back at the judge. Then, and this is the moment that everyone present would remember, the moment that was described in every account of that morning with remarkable consistency. He smiled. Not politely, not nervously, fully, with the specific confidence of a man who has survived too many of these rooms to be genuinely worried about this one. And then he said, Your Honor, with respect, we both know how these things work. This'll get sorted out. The room went completely silent, not the ordinary quiet of a proceeding, something different. The kind of silence that descends when everyone present realizes simultaneously that something irrevocable has just happened. Judge Morrow looked at him for a long moment. I'm sorry, she said, not angry, genuinely asking for clarification. Marcus's attorney put his hand on his client's arm. Marcus did not appear to register it. I mean no disrespect, Marcus said, but we've been through this kind of thing before, and there's always a workable resolution. I'm confident we can find one. Judge Morrow set her pen down. She said, Mr. Ellroy, what you have just described, how these things work, is not how this courtroom works. And your confidence in finding a workable resolution suggests a misunderstanding of your current position that I would like to correct immediately. She looked at the court officer stationed near the door. What she said next was quiet, measured, and without any theatrical weight. It was simply an instruction. Please approach the defendant. Marcus turned his head. The court officer was already moving. Marcus Ellroy, I am finding you in contempt of court, effective immediately, for the pattern of non-compliance documented in this record, and for the conduct displayed in this proceeding. You are remanded to custody pending a formal contempt hearing. The court officer reached Marcus's chair. From the moment Judge Morrow finished speaking to the moment the handcuffs were applied was, by the accounts of those present, approximately 60 seconds. Marcus Ellroy looked at Philip Carver. Carver was already on his feet, speaking rapidly about due process and the right to be heard. Judge Morrow acknowledged him and said the formal hearing would be scheduled within 48 hours, and that Carver was welcome to present any arguments he wished at that time. The handcuffs were applied. Marcus Ellroy, who had arrived in a charcoal suit and an expensive watch, who had smiled at a federal judge, who had expressed confidence in finding a workable resolution, was walked out of the courtroom through the side door. Grace Teller watched him go. She did not smile. She did not react visibly. She looked at her legal pad and wrote the time in the margin, the way she had written the time at the start of every hearing for 18 months. Then she sat back in her chair, for the first time in a long time, without writing anything at all. The contempt hearing took place 2 days later. Philip Carver was competent and well prepared, and he made the arguments available to him, that the contempt finding had been premature, that his client's statement had been poorly worded rather than deliberately disrespectful, that the technical delays in producing documents were genuine rather than strategic. Judge Morrow heard all of it. Then she upheld the contempt finding. The sanctions she imposed were not small. Daily financial penalties had been accumulating from the date of the first missed compliance deadline. Those penalties, calculated across 11 days, represented a significant sum. She also imposed an immediate order freezing Vantage Parallel's operating accounts above a specified threshold, pending production of the financial records. The freeze meant that the company could meet payroll and basic operational expenses, but could not make distributions, pay executive compensation above a set level, or conduct transactions above a specified amount without court approval. The intent was clear. The tools that had been used to avoid compliance would not be available for further avoidance. The financial records were produced within 56 hours of the contempt finding. What they contained was not a surprise to anyone who had been paying attention, but its documentation was significant. Over the 36-month period covered by the order, the redirection of employee-deferred compensation funds was clearly visible in the financial records. It was not hidden in any sophisticated way. It appeared in line items, in transfer authorizations, in approvals that carried Marcus Ellroy's digital signature. The money had moved in ways that were traceable, documented, and, once the records existed in a form that could be analyzed, very difficult to mischaracterize. The civil case, which had spent 17 months in procedural obstruction, resolved within 3 months of the records being produced. The settlement required Vantage Parallel to repay the full $900,000 in withheld deferred compensation, with interest calculated from the date each employee's contributions had been redirected. It required Marcus Ellroy personally to cover a substantial portion of the plaintiff's legal costs, which had accumulated significantly over the duration of the case. It also required, as a condition of the settlement, a formal acknowledgement, on the record, in language that could not be described as ambiguous, that the funds had been redirected without the employee's knowledge or consent. Marcus signed it. He did not smile when he signed it. Grace Teller received her settlement check on a Thursday afternoon in September. She sat in her car in the parking lot of her bank for a long time before going inside. She called her sister. She did not have an elaborate plan for what she would do with the money. Most of it would go back to where it had come from, the savings account she had drawn down, the loan she had taken against her retirement fund to cover the legal fees during the years when resolution seemed perpetually out of reach. What she told her sister, on the phone in that parking lot, was not about the money. It was about the moment in the courtroom. She said, "I've watched him walk into that room 17 times, and every single time he looked at us like we were an inconvenience, like we were something he was going to outlast, and then he smiled at the judge, and something happened that none of us expected. And I realized he'd never once been in a room that didn't adjust to him, not once in his whole career, and this one didn't." She paused. "That's the thing I'll remember," she said, "not the check. The room that didn't adjust." Marcus Ellroy resigned from Vantage Parallel 6 weeks after the settlement was finalized. The company's board, which had been largely passive throughout the litigation, moved with notable efficiency once the contempt finding and the financial records became part of the public court record. His resignation was announced in a brief statement that cited a mutual decision to pursue new directions. The statement did not reference the settlement, the contempt finding, or the $900,000. No one was confused about the context. A separate regulatory review, initiated by a state financial authority following the publication of the court documents, was ongoing at the time of his resignation. The outcome of that review is part of a different public record, in a different filing, in a different office. But it begins with the documents that a judge finally compelled into existence on a Wednesday morning when a man smiled at the wrong person. The employees who had filed the case did not become famous. They did not write books or give interviews. They went back to their lives, to jobs they had found in the years since leaving Vantage Parallel, to mortgages and children and the ordinary texture of things. Some of them had recovered financially before the settlement. Some had not. The money helped everyone in some way, and for a few it made a meaningful difference to decisions they had been deferring for years. What united them, in the accounts they gave to people they trusted, was not the settlement itself. It was the experience of being inside a system that had been designed, it sometimes seemed, to wear them down, and not being worn down, of watching motion after motion, extension after extension, delay after delay, and continuing to show up, of sitting in that room 17 times, and then an 18th time, and watching the room finally do what rooms are supposed to do. This is what long, difficult, legitimate legal fights look like from the inside. They look like exhaustion. They look like doubt. They look like sitting in a courthouse hallway eating a sandwich you brought from home because the legal fees have consumed the kind of discretionary income that allows for courthouse cafeteria sandwiches. And then, sometimes, they look like a court officer walking toward a man in a charcoal suit. Marcus Ellroy had operated for 2 decades on a theory of invulnerability. The theory was not articulated. It was not conscious. It was the accumulated residue of 20 years of not being held accountable in any way that cost him something he could not replace. Money had been a cost he could absorb. Reputation had occasionally been a cost, in the sense that some people had formed unfavorable opinions of him. But the opinions of people who couldn't affect his business had never been a real cost. Time had been a cost, in the abstract, but his time had always been manageable because the people managing it were paid to manage it. What he had never lost was freedom of movement, the ability to get up from a chair and walk out of a room when he was ready to leave. On that Wednesday morning, that changed. And it changed in the most public, most unambiguous, most irrevocable way available to a civil courtroom. A physical action, witnessed by everyone present, that could not be described as anything other than what it was. The theory of invulnerability did not survive the handcuffs. Judge Sandra Morrow did not comment publicly on the case after it concluded. She doesn't do that. Judges rarely do, and the good ones almost never do, because the work speaks for itself and commentary would diminish it. She continued her caseload. She continued her habit of reading everything, asking questions that demonstrated she already understood the answer, and extending reasonable patience to people who deserved it, and not one day more to people who had forfeited it. In the months following the case, her courtroom saw no shortage of defendants who had received word, through the particular information network of corporate legal circles, that she was not a judge who adjusted to the room. Some of them adjusted their behavior accordingly. Some of them did not. Those who did not are part of other stories, in other records, in other filings. She continues. What does it mean when a man in a position of significant institutional power laughs at a court order? It means, in the most immediate sense, that he has miscalculated. He has confused the patience of a system with the powerlessness of that system. He has mistaken the slowness of consequences for the absence of consequences. He has believed, one time too many, that the room would adjust. But it also means something larger. It means that the employees who spent 17 months being worn down by procedural delays were right to keep going, not because the outcome was guaranteed. It was not. Not because the system worked efficiently. It did not. But because the system, slowly and imperfectly, and at great cost to the people who depended on it, worked. It produced a contempt finding. It produced financial records. It produced a settlement. It produced a man in handcuffs for 60 seconds in a room full of witnesses. And it produced something that is harder to quantify, but just as real. The knowledge, for 12 people who had spent years being treated as inconveniences, that they were not. Grace Teller still takes notes, not in courtrooms anymore. She has no reason to be in courtrooms. She takes notes in meetings, in her new job at a different company, in a role that came with a proper employment contract she read 3 times before signing. She takes notes because she is the kind of person who takes notes, and because the habit never really goes away once you've understood how important it is to have a record of what actually happened. She does not think about Marcus Ellroy regularly, but occasionally, when a meeting runs long and a decision is being deferred for reasons that don't quite make sense, or when someone with more authority than accountability makes a statement that no one challenges. She thinks about a Wednesday morning in spring, about a man who smiled at the wrong person, about 60 seconds that rewrote the end of a story that had seemed for a very long time like it wasn't going to end well. And she picks up her pen, she writes down the time, and she keeps going.